And this session has been brought to you by our generous sponsor, Gravity Legal. Now, it's my absolute pleasure to introduce you to our speaker, Emil J. Emil is a partner at McCabe & Ali LLP, where he provides legal representation of patent and trademark attorneys in professional conduct investigations and enforcement actions initiated by the OED and state bars. Formerly at OED, Miekel helped to promulgate the USPTO rules of professional conduct and is a registered patent attorney. As one of the only former OED attorneys actively representing clients before OED, his experience affords him a unique understanding of the regulation of IP professionals from multiple perspectives. Miekel is also an adjunct professor at Lewis and Clark School of Law and vice chair of the ABA IPL Ethics and Professional Responsibility Committee. He blogs about IP ethics issues at www.oedethicslaw.com. So make sure to check that out. And with that in mind, let me pass it on over and make sure you can get started with everything. Miekel, thanks so much.
Lauren, thank you so very much. So let me just make sure my slides show up. There they are. All right. So today we're going to take this opportunity to dive into legal ethics, especially as it relates to IP practitioners. So I'm sure many of you have taken Ethics CLEs on a number of occasions and probably think they're a bore. And even as an ethics attorney, I will agree with you wholeheartedly. So today I'm going to try to take a little bit more of a practical perspective. So speaking to you as an IP attorney that also focuses on ethics, I hope that I can give you a little bit more practical ways to think of things and maybe kind of a survey of some important areas of concerns for IP practitioners. I'm trying not to scare you with cases of disbarment, and again, just give you a little bit more of a practical perspective. So in doing so, I like to first explain to people how they do practice before the USPTO. So first of all, probably half of you, if I were to take a survey, will probably come to me and say, well, what is OED? I've never heard of OED. I'm a trademark attorney and I am subject to only my state bar rules. And we'll get into that in a second. But first off, for the patent attorneys in the room, you probably have taken a registration exam and qualify to practice in patent matters before the USPTO. But when you practice trademark law, whether you are a patent attorney or otherwise, your basis for doing so is under the Administrative Procedure Act. As members of the bar of any state, you can practice in trademark matters before the USPTO, but of course you cannot automatically practice in patent matters unless you're registered. The key, though, is you must be active and in good standing and not otherwise suspended or excluded by the USPTO to practice in these matters. And again, I don't want to bore you too much, but I wanted to give you a little bit of introduction on this issue. So the conduct of attorneys is regulated by federal law, by the Patent Office, specifically under 35 USC 2, which allows them to regulate attorneys and agents, as well as perform moral character evaluations. And then 35 USC 32 allows them to discipline you. So does this mean there's preemption of state law? Not necessarily. So many of you might be familiar with this famous Supreme Court case from 1963 called Sperry v. Florida. It basically allowed the federal government to have an kind of an enablement of express preemption for patent law. But it still mentioned there that the state maintains control over the practice of law within its borders, except to the limited extent necessary for the accomplishment of the federal objectives. In other words, state Supreme Courts can generally regulate the practice of law that occurs. Generally, it's physical. It's called a button seat requirement. So within the borders of their states. So the issue is that the USPTO promulgated its own set of rules that are very similar to the ABA model rules and are basically applicable in 50 states, the USPTO and DC. So trademark attorneys, though, fail to realize that the USPTO likely has jurisdiction over them, both for trademarks as well as other matters, even beyond their normal state bar duties. So today we'll talk about a recent OED focus or a few focus areas, which in my opinion might be based upon the advent of foreign filings or the increase in foreign filings. So OED may initiate investigations into the conduct of trademark and, of course, patent attorneys through maybe a grievance filed by a client or a third party, other information or evidence from any source that might suggest grounds for discipline. And of course, They can close it with no action, which is great, warning letters, which is also okay, diversion, public or private discipline, which could be as a result of settlement or formal charges. And they do so by doing a clear and convincing evidence standard, which, as you might know, is just slightly higher than a preponderance of the evidence. So again, a majority of you trademark attorneys are not familiar with OED. So I'll say that the good news is that likely there's probably around maybe almost 100,000 folks that practice trademark law on potentially an infrequent basis, but there's only somewhere around 100 cases per year related to issues dealing with trademark practitioners before the USPTO. However, that number has increased significantly and continues to rise. So that being said, the information that OED learns about, or the state bar learns about, can come to from many different sources. So potentially some of the more recent cases I have seen are competitors filing actions against you for allegations of the unauthorized practice of law, maybe a former colleague getting revenge for something that they knew about that you were doing that may not have been on the up and up. But still, most are just client complaints and internal USPTO complaints. So for example, a client may complain that you failed to notify them of an office action. A client may say that you forgot to file a renewal. Or of course, the USPTO may look at a filing and say, this looks suspect. So an examiner or somebody in the post-registration department might send something up to the commissioner's office and say, hey, this deserves a second look. It looks like this particular attorney is making odd filings, and we need to work something out as it relates to this. Maybe send this to OED for further review. So again, I mentioned earlier that there might be an issue with bar rules being applicable. Well, yes, some people may think that only their state bar rules apply in most situations. Unfortunately, that is not correct. So while the USPTO did not adopt Rule 8.5, which deals with both disciplinary authority and choice of law, in most jurisdictions, you're subject to the rules not only of where you're admitted, but also of where you practice. Again, so while they did not adopt the same rule, you're encouraged to kind of look at rules 11.37 CFR 11.5 and 37 CFR 11.505. So again, what's the deal with this? Well, you might be an attorney in, let's just say, New York. And as a New York practitioner, you might be subject to the New York rules of professional conduct. But if you engage in any sort of conduct and say a client complains about you, they're free to file that complaint with the USPTO or the state of New York. And unfortunately, the USPTO may still investigate those allegations of misconduct, even if it has nothing to do with patent, trademark law, or the USPTO. They may give more deference to what New York does, but generally speaking, they will initiate their own independent investigation into that conduct, which again rises to the level of fact that you might be fighting an issue on multiple fronts. So how do you avoid fighting this issue? Well, I'm going to walk through a few practical steps of what you can do to hopefully avoid the ire of OED and your state bar. All right, so some of the common pitfalls that I've seen in trademark representation include fraudulent specimens or false statements of use. And again, many of you are going to say, well, we never do that. And agreed, I hope most of you are not doing that. But I think one thing we're going to talk about is what happens when you receive something that might be suspect or might be perceived as suspect from a client. We're going to talk a little bit about signature discrepancies and the right way to sign applications and documents filed with the office. We're going to talk a little bit more about foreign filings. As I mentioned earlier, I think that's some of the issues that we've seen deal with foreign filings, whether they're clients that are actually foreign applicants or filings that originate from different countries. Then there's the unauthorized practice of law, a few best practices, and I'm going to do a little bit of a tidbit on your conduct outside of the practice of law. All right, so let's start with fraudulent specimens or false statements of use. So I include specimens and statements of use together because I think they're often a very singular issue. Because when you file a specimen, you generally are also filing a declaration with it. And when the specimen is bad, your declaration is going to be bad as well. So first of all, I'm going to ask you a quick question. I'm going to try this poll out over here. tell me if you, in your case, if you're able, hopefully you're able to see this poll, but if you actually do sign your trademark applications or the declarations that go with it. Let's see if that actually works. All right, it could be because you all are in a different system that maybe you can't see my poll. But in any event, oh, it looks like somebody's able to respond. So while I'm waiting for that response, I'm going to get into what the issue is. So the issue with signing a response or signing a declaration on behalf of your client is that you need to be aware that if that information turns out not to be correct, the USPTO may come after you for that conduct. So think of a hypothetical where a client states that they use the XYZ mark in 2 classes. They show you one specimen showing one class, and you file the application. But later, you file a statement of use for the same mark based upon direction of your client. And at some point, whoops, that went to, all right. I'm sorry about that. So later on, the USPTO believes that the mark is not presently being used in commerce. And this could be years later. And they ask you for your basis for filing that application, whether it's OED or maybe the USPTO just asked for more information about that second class. The question is, did you do enough to provide that you did more than take the word of a client, right? This hypothetical is real, but I guess before we build upon it, let's talk about specimens for a second. So let me actually, looks like just a handful of people said, do you have your clients, that they do in fact have their clients sign the applications, declarations and responses. Again, as I mentioned, that is a best practice. So I'm glad that you all do that. So I'm going to take you to probably one of the most well-known allegations of fraudulent specimens, which was against a gentleman named Mr. Matthew Swires. And this case was publicized in a federal charge that was filed by Mr. Swires against the USPTO back in January 2016. So basically, the public records show that back in 2015, the USPTO, the OED, was actually investigating Mr. Swires for various allegations of misconduct, including allegedly doctoring specimens, or at least trying to submit doctored specimens to the USPTO. Ultimately, Mr. Swires was excluded on consent, of course, after he sued the USPTO for what he called were CAFLesque treatment by the USPTO. And the final order from OED alleged that Mr. Swires violated multiple rules by, among other things, failing to adequately supervise his employees or adequately review their work, thus permitting them to create false or fraudulent specimens and or digitally altered images of the marks that did not depict the actual mark as used in commerce, and file those specimens with the office. And as a result, in some cases, the USPTO issued trademark registrations based upon the false or fraudulent specimens or digitally altered marks, putting the validity of the resulting trademarks in jeopardy. So first, just to be clear, the USPTO does not, as a matter of course, invalidate registered trademarks because of bad specimens. And the reason I say that is because there's a citation in the TMEP that I often cite to, which states that the USPTO is not in a position, like the examining corps is not going to suddenly say, oh, well, you know what, 2 years ago we had this bad specimen filed and we don't believe you, we're going to go ahead and revoke this registration, right? That generally doesn't happen. The USPTO delegates that task or reserves that task to the court system. So it is entirely possible that these marks that we're going to show some pictures in a few moments could be invalidated, but that invalidation would happen by and through a court system, right? A DEC action or some other action that might happen, saying fraud was committed on the USPTO. So yes, you should take this very seriously, but it is not the USPTO that does the invalidation. Instead, OED will be coming after you potentially if they find out about a clear pattern and practice of this. So for example, the one thing that I would say is what happens when a prospective licensee or purchaser sees a suspect specimen. So, you know, while this, of course, might not be a very common issue that you might see in your day-to-day practice, the takeaway that I would give you is verify your client provided specimens. Again, it's unclear whether or not the issue in Mr. Schweier's case was his clients providing false specimens, or in fact that the staff or Mr. Schweier himself was creating these false specimens. But again, the example is that you really need to police your own specimens that are provided to you before you file them, because once you're submitting them, even if you're not signing them, it is something that you should be mindful of. So let me show you a few samples of some bad specimens. And many of you who may have actually seen me speak in the past may have probably seen these before. And I just think these are just amazing to look at. So for example, what I like to say is if you look at Live Deep over here, you can clearly see this hang tag when you look at the pixelation around this, and you may not be able to see it clearly on your screen, but you can totally tell that somebody superimposed the word Live Deep on top of this hang tag. And same thing over here, what says, I think it says Trill Guys Wireless Inc. And again, you can totally tell by the discoloration or the different color between the white part of the headphones and the white background of the logo that this is in fact a fraudulent specimen. And another example of a hang tag, my block, my hood, my city. Again, you can totally see not only the pixelation over here, but you can also see the different coloration of the different shades of white. So again, many of you are going to say, well, I would never do this. And again, I hope you would never personally create a false or fraudulent specimen. But I think the issue is going to be, what are you going to do about it, and how are you going to explain to your client that this needs to be changed? So I'm going to take a quick moment to talk or to answer some of these questions. So one of the questions says, what if you find out that it's altered after the trademark issues? Do we have a duty to do something? And that's a very good question. So there's actually an ABA ethics opinion that deals somewhat with this issue. I mean, it really deals with a mistake. And it's very fact intensive, right? The idea is, what was the issue, right? Did you knowingly submit a false statement to the court? I mean, because we're going to look at 3.3, and the USPTO says that they're a tribunal. And when you file something with the examiner, you're basically making a false statement to the Commissioner of Trademarks in which they relied upon. Well, generally speaking, once the registration issues, your power of attorney ends, period, right? That's written in the TMEP that the registration is what makes the trademark, sorry, I think the thing may have already, all right, so I think my slide may have advanced inappropriately, but going back to the question, if you find out that something has occurred, you probably have a duty to discuss this with your client. Whether or not you have a duty to necessarily rectify this with the USPTO really is fact dependent on the situation you're in. So one, you may have an opportunity where you've already withdrawn from the representation, so you don't necessarily have an affirmative duty, but let's just say that you still represent the client. The best course of action in that situation would be to say that you have an affirmative duty to make an amendment, right? To file a post-registration issue to correct the issue, because beyond that, you'd also want to analyze whether you have a post-registration filing that may come due, and if there might be a reasonable chance for you to correct that record in the near future, that might be most appropriate to minimize harm to your clients. But it's really fact intensive depending on where you are in the situation. And then the next question had to do with, by client signing the declaration, do you mean sending them a link for signing or signing the name on the application? And I'm going to pause that question for a second because one, in this particular instance, I was talking about sending the link to the client. But in terms of signing the name on the application, we're going to discuss that in just a moment. All right, so as it relates to fraudulent statements and false statements and fraudulent specimens, remember, it's common but not a best practice for a practitioner to sign the response under their declaration. I'm, again, not saying that there's anything unlawful or inappropriately doing so, but it's just not the best practice, because when you're submitting a specimen and you're declaring that the mark is being used in commerce, you are doing so after a reasonable inquiry. And this would be very similar to the Rule 11 inquiry that you do. It is under 37 CFR 1118. This does not mean that you're flying out to a client's office, but it does mean you are performing some sort of due diligence. I will get into this a little bit later in a few slides, but during the Goods and Services Audit Program, if you delete goods or services based upon a request from the USPTO, it's not a very good sign. But again, let's kind of discuss maybe what baseline competence means, because if we don't meet the clients in person, in these Zoom times, what can we do? So baseline competence, I'm not seeing my slides advance. There it is. Okay. So OED expects practitioners, and again, these are my words, but they want you to have a client discussion, right? You want to have a discussion pursuant to 11.104, which is the communication rule, right? You want to review the specimens and you want to ask some questions, right? You want to make sure, okay, well, you showed me this specimen. Can you explain what this specimen describes? Does this specimen also show that you're using it in this fashion, right? If there's a problem with a specimen, can you ask for some better proof or better specimens? And then more importantly, have some proof that you did the above, right? So for example, if a client shows you that a specimen with a hang tag that appears to be photoshopped, can you ever submit it? The answer is potentially yes, right? It just appears to you to be Photoshop. But if I were to have submitted such a specimen, one, I would say, well, maybe I could submit 2 or 3 specimens, but 2, I want to create a written record. And I want you to listen very carefully on this. And I say this very seriously, that if you don't have a written record of something, it never occurred, right? I enjoy talking to clients on the phone. I enjoy just having that one-on-one communication because it allows the client to ask me follow-up questions, right? So if a client says, can I do this? Or, tell me about this, I'm more than competent and more than capable of sending them a great response in writing. But it ruins the human element of being able to ask follow-up questions. So I always try to make myself available by telephone to answer follow-up questions. Well, the problem is that how do I make a written record of that phone call? And if any of you have talked to me in the past, you know that I'm always about creating a written record, whether it's by phone call notes that you somehow append a date to, so maybe emailing them to yourself, or a confirmation in writing. So you might say, well, I had this phone call with you. So dear client, pursuant to our phone call, you indicated that while this hang tag looked somewhat inappropriate, you confirmed that it was in fact correct, and you did show me these other images. I'm still going to therefore use this along with these other images and submit them to the USPTO, right? Those are really important. But even if you don't go that far, maybe it's saving copies of their website that show the mark being used in commerce, or maybe other evidence that you've seen. It doesn't always involve asking your client, especially if it's readily apparent, but show your work, right? Remember when you were in 2nd grade and your teacher said, yes, that's the right answer, but you need to show your math work that you did? Same thing here, right? The question is, why should you risk submitting something that looks fake, right? Because this implicates issues 11.101, 11.103, and 11.804. All right, so let's move on to, it looks like there's more questions. All right. So one attorney here said, not if it's a new client. In this case, this particular person said that they got subpoenaed. This attorney said they got a subpoenaed in a federal court case since they assigned the substitute specimen. Another great example of why it may not always be appropriate, because why would you want to get subpoenaed in a case? And then another person says, I don't have the client sign, but I do use the alt legal form and make sure they confirm or say before filing. And never for statements of use unless it's a long-term client I know well. So yes, I mean, again, I think it's appropriate in many cases to do so, but this particular attorney says they do so only if it's a client they know well. So maybe it's based upon a long course of conduct. And another person says, how do you all get clients to sign applications, statements of uses, and declarations? Do you prepare the filing and then send them the file for them to sign and submit, or do you get their permission to sign the declaration on their behalf? And again, this is an issue I'm going to get to in just a few moments, but the latter, I will just say, no, you should never sign on their behalf. You should never sign another person's name. And then another attorney said, is it best to file an extension along with the statement of use? if there's concerns on the specimen, if close to the deadline, and extensions are available. Well, that's a good question. Well, I think the first thing is that should you be filing an extension without the client's permission? And the answer is probably not. So you probably want to first explain the issue to the client. And then, obviously there's fees associated with it. You want to let them know the pros and cons. And you probably need to put in a hard line of whether you are willing to file a submission that is suspect. But again, it's a very fact-intensive inquiry. But before we get to the questions about the signature, let's move on quickly to foreign filings. So the USPTO is really good at big data. So OED has placed a large focus on trademarks, and as a result, we have these post-registration audits that are coming forth. And a lot of you are like, well, how do they know about this? Well, the USPTO captures all sorts of data, right? They do all sorts of sophisticated analysis. I mean, they know things like the country that it's filed from, obviously, but not only the country where it's listed on the application, but also the physical country it comes from, because they do have the IP address of the filer. But not only that, they also have the ability to procure the IP address of the signatory, as well as things like application status. They can find out whether a lot of applications are going abandoned, things like that. And prior to this focus, I considered, on a personal note, trademarks to be a cash cow for the USPTO, because they had many folks that were filing pro se applications because they considered trademarks to be an easy IP right? It was a win-win, because attorneys were getting a good chunk of work coming to them. Pro se filers were getting, let's just say, wins where they could say, I have a pending trademark application, thinking it was similar to patent pending. And finally, the USPTO was getting filing fees and was able to kind of keep some efforts going. But obviously, in May of 2019 at INTA, Director Urianku kind of made his very most famous statement, I think, about trademarks. He said, over the last few years, the USPTO has seen a tremendous uptick in foreign applications with inaccurate or possibly fraudulent claims of use of the mark for the goods or services that were specified in the application. And, how does this relate to the rise in foreign filings? Well, the USPTO wants to potentially clean up the trademark register and maybe protect American interests, right? I'll be very frank with you. The USPTO does not have a good structure to go after filers, so they go after the practitioners that help them, right? So what have they done to prevent some of these filers from going at it alone? Well, they've made changes, including requiring you to log into Tees. At some point in the near future, you're actually going to be required to add an ID, which I understand will be either a passport or certain types of other identifications. Again, since they allege that they can't go after filers, they go after what I consider to be low-hanging fruit, which unfortunately is you all. All right, so the USPTO did recognize the nature of these bad actors, and what they did was they created this US Council rule, right? Because they have a duty to balance, right? They created the Council rule to tamp down on fraud on the USPTO by applicants who might have been pro se. And in this case, the location of the applicant is key. The USPTO represented in the notice of proposed rulemaking that the practice would be an effective tool for combating the growing problem of foreign individuals, entities, and applicants of failing to comply with US law, right? US law might be the use in commerce, could be so many other things. But what was the hidden benefit to some extent? Well, there was an increase in attorney-led filings that spurred trademark practice. Maybe, right? Well, not always the case. As many of you might have seen, there was this gentleman named Bruce from China, right? I remember when this came out, this was, and I actually received this email from Bruce from China, as did dozens of clients and attorneys, many of them who claimed that they would stay away, but others who thought it would be a great idea to get involved with what the OED and the bar community might call renting out your license, right? Quite frankly, what Bruce was asking for is the ability to use your bar registration number and your Tees login number to basically submit applications and use your signature to do so. And the chances are, if you're being offered by somebody to pay or to get paid a few dollars for every application, whether 10, 20, 50, whatever, you're probably acting unethically. Said another way, if Bruce or somebody else says they're going to use your T's login to file 100 applications a day and pay you, just say $1,000, it brings up a whole host of issues that you should not be getting involved with, right? A U.S. attorney filing 100 applications a day is already a lot, but then add the fact that those applications are being filed from a foreign IP address, that's going to be suspect, right? That's definitely going to get you a referral to OED. And once we get into a look at the quality of the applications, we look at the specimens, we look at the use, oh boy, that's going to be quite an issue that you're probably going to need to address and potentially have some sort of disciplinary action against you. So of course, the question is, how did you sign so many applications? And this is where we're going to get into some of these questions regarding the signature issue. And it's funny, Robert Pierce asked, did anyone fall for this? And unfortunately, yes. I don't know if it's specifically Bruce, but many other people have done so. And Cheryl says, these foreign applications are absurd. They don't even have to claim use, so they file for every item in a class, and then they get the registration for 6 years without use in the United States. And I'm not sure if you're talking about a 44 application or if you're talking about the a fraudulent use case, but this is a major problem that has occurred for many years. And like it or not, the USPTO is doing something about it at this stage, and that's why practitioners just seem to be mindful about this. So let's take a deep dive into signatures. So under 37 CFR 2.193, this rule basically talks about some of the important aspects of signatures as it relates to trademark correspondence, right? I'm not talking about who is the person to sign on behalf of the entity. That's a different rule, which I'm not going to get into in depth. But here it just says that every correspondence that requires a signature, which is most correspondence filed through T's, must either have a handwritten signature personally signed in permanent ink by the signatory or a copy of the same. So that would be, for example, I'll give you an example. Many celebrities or famous people tend to love to sign their trademark applications or responses, et cetera. So whether it's Kobe Bryant, the late Kobe Bryant, Donald Trump, Michael Jordan, all these things, if you look at some of their applications, a lot of them will have a handwritten signature. And I'll talk about what that's classified. It's called H-sign-on. But the more common signature that we're going to see is an electronic signature that meets the requirements of paragraph C of the section, which I'll talk about in the next page. And again, here it says it has to be personally entered by the person named as the signatory. So if your client's name is the named signatory, it must be personally signed by the client. If your name is the named signatory, it must be personally signed by you, not your paralegal, not your legal assistant, not your spouse, not your associate, not your partner, no one but you, right? So the USPTO, again, has been extremely picky about signatures. And just in the past year, they've probably disciplined maybe at least 7 or 8 trademark attorneys for this specific issue. And there's probably half a dozen at least pending cases that involve the same issue. So going on to paragraph C, which was mentioned in paragraph B, the requirements for an electronic signature are quite clear. So again, 1, you must personally enter the combination of letters and numbers, spaces, whatever you use between 2 / symbols in the signature block of the T's submission form, right? Again, it's personally. I underline personally because my emphasis is there. And as much as the e-sign Act and common practice might convince you to sign on behalf of a client or a colleague or let somebody else sign on your behalf, the USPTO believes it's a no-no. And again, I'm sure you're already annoyed that I probably mentioned this 4 or 5 times already, but I'm going to mention it one more time. If you sign an application, declaration, or response, you must type in your electronic signature yourself. Every time I write a blog post about this or somebody hears me speak, I'll get 2 or 3 people that'll email me and say, Emil, you're wrong. I've been doing this for 20 years, or I've been doing this for 30 years, and no one said a thing to me. Please don't tell me that, right? Unless we have an attorney-client relationship, because it is not correct. The USPTO may not have previously enforced that, but clearly they are enforcing it now. And again, under C2, there is a way to sign some other electronic signature form. The director has not, as far as I know, created any specifications on that. So for right now, DocuSign, Adobe Sign, Write Signature, HelloSign, none of those work. It has to be personally signed through the T's form. If you happen to get away with some other signature, that might be by pure luck, but according to the Commissioner's Office and the Legal Policy Office, no other signatures are permitted other than a hand signature or a T signature. So let's go back to some of the other questions that came up in reference to the signature. So, how are you able to submit the signature, right? Well, there's 3 signatures that are applicable in T's. These are the technical terms for them. They look a little bit different on the T's form, but if you look at the XML, which is the markup language that shows up behind the actual form, this is what they look like. So a direct signature is usually where the attorney signs the filing. So for example, in a very simple trademark application, whether it's 1A or 1B, it's going to be signed by the attorney, although best practice, again, might be the client in most situations. And in that case, the attorney literally fills out the application, types in the description, goes to the payment process, and signs the application. Perfect, right? They personally sign the application. Well, the more complicated setup is, what if you want your client to sign it, or your support staff is preparing the application for your review, right? In that case, in the latter case, the support staff may send you the OBJ file, but as many of you probably know, the OBJ file, whenever there's a T's update, the OBJ file might stop working. So we consider sending the e-sign-on, right? That's where you have a little button right in the center that says, send this link to somebody else to sign. Well, your support staff could send that to you to review and sign, or you might send that to the client to sign. It does not mean you send it to your personal email and then you sign it yourself under the client's signature. Nope. You sign it, you have the person that you're sending it to sign it personally by themselves, right? And how do you make sure that this is signed appropriately by the client? Well, you provide adequate instructions to the client. So if the client is a corporation and you have to have the proper officer with the authority to sign it, you can't just send it to the, maybe the assistant and say, hey, can you sign this? You have to say, dear assistant, I need to send this to you as the representative that I'm working for, the trademark administrator or whatever. But can you please have this person sign it, because we believe that they are the proper person to sign as the officer of the company. And then H-sign-on, as I mentioned, is where you might submit a hand-signed document. Again, this is probably one of the least common methods of signing, but it is still something that's good to know, because there might be cases where it might be appropriate for you to have the client hand sign a document, either for effect or because that's the most appropriate method. All right, so let's find out a little bit more about these signatures in the eyes of the USPTO. So again, signature duties are not delegable, right? Whoever is signing, whether it's the attorney or the applicant, the paper must include the person's signature, right? Some practitioners have been disciplined for conduct that includes allowing somebody else to sign a trademark submission. And more recently, I think some of you may have heard of Trademark Engine. That's probably a big one that happened recently. In this case, Mr. Travis Crabtree of Texas was excluded on consent, which basically means he gave up his license. And what happened was, they said that he was an attorney, and this is according to the final order. He was a Texas attorney that started Trademark Engine LLC in 2016. And it was to assist customers in preparing and filing trademark applications. And he was one of the owners, the general counsel, and the managing member. He was alleged to have drafted a procedure manual, et cetera. The USPTO alleged that when he began, all operations were, like all trademark applications, were signed by the customers using the e-sign-on method, right? So it all started well. However, from a period starting from 2017 until 2018, basically employees used a procedure that cut and pasted signatures onto trademark applications, usually after Trademark Engine customers reviewed the application summaries and agreed to the same verifications required on the USPTO application. So that looks very suspect, right? I mean, first of all, well, you might say, well, I It sounds like he had a good procedure in place, and it sounds like the clients consented to it because they affirmed that the information in the applications were correct. Well, unfortunately, the USPTO didn't think so, and they filed not only one, but two formal separate charges against him for the various conduct, and he ultimately gave up his license to practice before the USPTO. So even though he was a trademark attorney, he gave up his right to practice trademark and other law before the USPTO. And another example was Mr. Miekel. So in 2019, Mr. Miekel was actually given a reprimand for somewhat similar conduct. In this case, what they said was Mr. Miekel's company provided paralegal services to trademark clients. And he had the managerial authority over his non-practitioner assistants, even though, and this is the interesting part, even though those non-practitioner assistants, which is another name for paralegals, took direction from and were supervised by others. Again, that means that Mr. Miekel's employees, paralegals, were supervised by other attorneys, his clients. But contrary to the regulations that they cited in the final order, as well as the guidance in the TMEP, Mr. Miekel mistakenly, again, they acknowledge it's a mistake, relied on consent from each named signatory and permitted his paralegals to improperly sign trademark filings on behalf of the named signatories in up to 35 trademark filings. Again, to be clear, the TMEP unequivocally states that the USPTO does not take a position regarding the validity of the marks. And we have not seen, at least I have not personally seen, the USPTO void or invalidate marks for these sorts of reasons. But you can see in this case with Mr. Miekel, he mistakenly relied on consent. And not only did he supposedly had a duty to supervise them, but the actual practitioners that were performing these paralegal or that were getting these paralegal services from his company had some sort of supervisory responsibility, but Mr. Miekel was the one that actually got in trouble. So it looks like there's a question. I'm confused. S signatures are absolutely accepted under 37 CFR 1.4 D2 for patent filings. Why is it not accepted for trademark filings? And so that's an interesting question. So 1.4 is mostly related to the patent side of the business. So remember, part 2 deals with trademark filings, and S signatures are appropriate, but the requirements for S signatures are somewhat different for trademark filers than they are for the patent filer. So for example, 1.4 requires you to also put your registration number if you're a patent attorney on patent filings, but when you're practicing trademark law, you're not automatically required to do so because it is a different set of circumstances. So generally speaking, my understanding is the USPTO will not accept a filing if you, for example, try to do an S signature on a piece of paper and then scan it in and use the H sign-on method or some other way. In that case, if you're using an S signature, it has to be done in accordance with 2.193 and personally done through the transmittal system of the USPTO. All right, so let's talk a little bit more about another common issue, unauthorized practice of law. So we all know that you all are, probably majority of you in this room are attorneys. So why do I bring this up? Well, UPL is not only a violation for those who might engage in litigation where they're not properly licensed or filing a complaint, where you're not barred, but UPL is also when you assist another in violating these restrictions. So, of course, we've had patent agents that have been disbarred from the practice of patent law for prosecuting trademark applications. Yes, it did happen. I'm going to talk about it in another slide, but it's in Ray Shah. But recently, while the USPTO has not taken a position, some states have actually said that the practice of trademark and other federal law within their borders still counts as UPL if you're not licensed. So this is a very interesting consideration because I know many of you are probably trademark attorneys that may be barred in a jurisdiction where you are not physically present. In the negative, you'd say you're not barred in the jurisdiction where you currently are, whether it's because of coronavirus or because you've moved. And many of you said, well, I practice exclusively in trademark law. And that's okay because it's federal law. The guidance is somewhat unclear about that. It's very clear if you are practicing federal law as it relates to something like patents, which is exclusively in the federal domain. But trademark law involves potentially some common law rights. And there's no case that I'm aware of that's similar to Sperry v. Florida. That's not conclusively saying that that's inappropriate, but it is something that many states are still looking into and developing. I have yet to see somebody disciplined for it, but I would say your results may vary by state, but something to be cognizant about. I think it's always very important for you to be admitted in the state where you are physically present. So frankly, if you live in a state, try to be barred there. So what about some of the nuances of UPL as it relates to your non-practitioner assistants? Well, you're responsible for your staff. And as I mentioned earlier, right, where it comes to signatures, et cetera, well, we're not really talking about subordinate attorneys. There is a rule for that. I'm not saying it's not important. What I'm saying, though, is that you're supposed to give reasonable efforts to ensure that your firm has measures giving reasonable assurance that the conduct of your non-attorney staff is compatible with your obligation, right? So in other words, you have a duty to supervise, even if you're not a manager. So think of being an associate in the firm, right? If you, whether alone or together, or you have some sort of supervisory authority, which arguably as an attorney, you have some supervisory authority over any non-practitioner, you have a duty to make reasonable efforts to ensure your firm has measures in place to protect you from violations of the rules by your staff. So what is reasonable? That is a great question, and I would love to have an answer because there is nothing concrete, and I think it's a very fact-intensive inquiry. So for example, in the case of signatures, as we've discussed, have you properly trained your staff, maybe once a year, about how they're not allowed to sign something, right? That would be something. And have you reduced that training to writing, right? Did you do a PowerPoint presentation and save those slides and then send them out to the entire team, whether it's a one-person team or 10-person team? Did you ensure that there's guidance or corrective action taken in situations where somebody may have not said something appropriately? Like, so for example, maybe a paralegal took some direction from a trademark examiner when that shouldn't have happened, right? Because the trademark examiner probably should not be interfacing directly with the paralegal in most circumstances, right? They shouldn't be agreeing to substantive changes in a mark or examiner amendments. So how are you making sure that that's not happening, or if it does happen, that it's being corrected? So one question is, what about representing clients who live in a state where you're not admitted? I've seen opinions on both sides of this, and that's agreed. So that's, and again, I guess since we're on the UPL topic, I'll mention this to you. Every state is different on this, but I will tell you a majority of states these days go with what I call the button seat argument. If you are physically present in a state and opining on that state law, you are probably in violation of the rules. If you are physically present in that state and opining on another state's laws where you are admitted, you could be violating that state's rules. But if you were physically present in your state where you are admitted and opining on another state's laws to a limited extent, you're probably okay as long as it's reasonably related to your practice, et cetera. So again, it's very fact intensive depending on the states that you're in. One thing to be very cognizant of is to make sure it's clear to your client that you're not admitted in states where you're not admitted, right? So I'm only admitted in these states, or I'm only admitted in this state. That's probably very important. So somebody mentioned that they're required to input bar information. Yes, that's bar information of your state bar, not of your registration number, which I was explaining about Ms. Halpert's question. And what do you do with common issues with LegalZoom filings? Or I guess what do you all find is a common issue? And somebody else responded to that saying, do you mean a client who's asking you to fix a LegalZoom filing did on their own? So I can't really get too much into LegalZoom filings, but I will say that a lot of them are self-directed filings, which are similar to what Trademark Engine was doing. I guess you could say it's basically a form that's similar to T's that might have some annotations saying, hey, like exactly the same questions as T's with just a little bit more information. the chances are those are just as good as a regular pro se filing. So they have the same issues, bad specimens, they filed the wrong thing, 1A versus 1B. They didn't describe the good. They used T's plus when they should. I mean, there's very similar sorts of issues. So what do you do with them? Well, you do the same thing you do with any other filing, which is try to correct that issue and hopefully not have to start all over again, but really explain what the issues are in those in those applications. So I know we're running a little bit out of time, so I want to try to get through this. So some real world examples of UPL and other conduct. For example, I talked about Enray Shah, even though it says Shia, it's pronounced Shah. That was a lady who was a patent agent that represented trademark applicants before the USPTO, quite a number of them. And she was alleged to have engaged in the unauthorized practice of law because she was not an attorney and she was representing trademark applicants. I think one of her arguments was that she was just acting as a domestic representative and not doing legal work. This was, again, before the Foreign Counsel Rule, but again, a very interesting case. But you can also be administratively suspended in your bar or not otherwise in good standing because you didn't pay your bar dues or meet CLE requirements. And that's another way you could be prohibited from practicing before the USPTO in trademark matters by virtue of you not being eligible. And this could be something where not only your filings could be considered voided, which again, they're not going to invalidate them, but it could be considered void because they were not properly signed and ratified, but it could also bring up charges of UPL. And again, I'm going to say this again, like I mentioned just on the last slide, that your paralegals, like that you're supposed to supervise, right? Are they providing advice to clients or dealing with third parties like the USPTO without adequate supervision? So let me try to wrap up by saying some of the best practices. So one, know your client, right? Just like, just like some of the folks that wrote some comments talked about, it's really important that you know your client and have a good understanding of what they know and what they don't know, right? That's really important because it helps you get a feel for whether you can, trust them or not. I'm just going to go through some of these questions. So there's a question, were you suggesting to have clients sign the office action response even when a declaration is not needed? No, not necessarily the case. I think sometimes it may still be appropriate, but not always the case. I think my personal preference is whenever there's a declaration involved, see what's appropriate in your particular situation. But going back to the best practices, so you want to make sure that you have a good engagement agreement. So many states don't require engagement agreements, and the USPTO the USPTO does not require them either in most circumstances. But so, for example, you might say, well, it's a $500 matter, right? Or a $1,000 matter, or $2,000 matter. I don't need to spend an hour or 15 minutes or whatever creating an engagement letter. But it's still a best practice, right? You want to make sure the client knows the scope of the representation, right? What are you doing for them? Are you doing any post-registration work? Are you only filing the application? Are you doing the response to office actions? When does the representation end? Those are all key elements. Even the simplest of representation should have an agreement, right? If you have a 20-minute phone call, maybe you don't need one, right? But it's still a best practice, right? And what about counseling clients? Are you giving them more than that cursory information? I realize that you're fighting with other folks, right? You're fighting with online filers that are doing things for $100, $200, whatever, but those are not attorney-led filings. You're an attorney. Your job is to do not only a good job for the client, but do your fiduciary duty in your representations to the tribunal, so to the USPTO. But beyond that, make sure you properly counsel your clients, right? Give them that value add because that's what's going to make them come back to you. And then conflicts checking, right? That's the other big thing, right? In some ways, trademark representation can be a zero-sum game. Right? What's the worst case scenario? Well, you represent a client and all of a sudden take on another client for a very similar mark that's cited against them. And, then one says, well, can you get a coexistence agreement, or can we do something, or can we do a proceeding against the other? Those are all issues that will probably require you to withdraw from both. And then, of course, post-registration duties. One, maybe you should outline these issues to them. Say these are the deadlines that will happen in the future, and this is what we can or cannot do to help you with it. And then once you are at that position, what are your duties to make sure you're doing things accurately? And then, of course, my final tip is, do a self-assessment, right? Or get a professional assessment to show compliance. And just like you would tell your client to get professional legal advice, you should consider the same. So any insight on current OED practice regarding the attorney responsibility for auditing goods on Section 8 filings? Yes. So one, make sure they're accurate, right? I mean, you want to make sure that when you do any sort of post-registration filing, that you have an adequate basis to say that those goods and services are being used in commerce, right? So again, if there is a very long description that has multiple goods in the class, are you ensuring that that one, and I had a really interesting case where there was like a conglomerate that I had never heard of that had all these interesting goods under a specific class. And I was like, oh my God, this person should never have filed this Section 8. But then we did a quick Google search and we found that particular client was in fact using those goods, and we found a catalog that we cited. And this was actually because some goods were deleted based upon client instructions. OED got involved and said, hey, you had this happen on 4 or 5 cases. Tell us why it keeps happening to you. And it was all confirmation. There was a good record, a good clean record showing the attorney going back to their client and saying, hey, we received this, we need proof. And the client says, just delete it. Not, oh, we don't have proof, just delete it. And again, that's suspect because it should never have gotten there, because you should have been able to say, hey, we have these specimens, or whatever, let me do this. Because of course, some people decline to submit further specimens because they don't want to pay your fee. And maybe the good way to avoid any further inquiry is to say to the client, hey, I'm happy to do this at no charge. I mean, again, I don't want you all to lose money or to waste time, but it could be a good way to not get involved in any sort of problems with OED. So what happened? Let's see. Flat fee or subscription models make it easier to get to know your clients and your clients get to know you. Yes and no. I think I have somewhat of a problem to some extent. I'm not saying that they're bad at all, but I do have a little bit of an issue with flat fee or subscription models. I think my experience is that attorneys that use those models are not doing proper conflicts check, because they basically say, pay me $1,000 a month and I'll do everything for you. And they may have conflicts from time to time, and it creates problems to their clients, which results in bar complaints. It is a good way to get to know your clients, but it could cause some issues. And I think that we are doing a CLE check-in.
Yep,
right,
exactly.
Okay.
Just wanted to make sure everybody got the code. Thanks so much. The code is W like WIPO, L like lapsed, the number 8, the number 3, and D like descriptiveness. WL83D. I'll come back at the end and announce it again, but take it away. Thanks so much.
Great. So I know we're running out of time. I'm going to try to run through this. So here's a quick hypothetical. So tmmatch.com, I don't know if that's a real company, sends you a, let me see, it looks like my slide didn't advance. Okay. TMMatch sends you an email saying they offer trademark services to clients all over the world, and they want to refer you a few matters for trademark prosecution. And you're going to be paid a flat fee of $250 to prepare and file the application. Thankfully, your intake form captured all the information, or their intake form captured all the information you needed. It's very clear what those individual clients' needs are. So who is your client in this case, right? I'm going to be very simplistic. The client here is that end trademark applicant. And this seems like an amalgamation of fee share and conflicts of interest, communication issues, and aiding in UPL, especially if TMMatch is owned by a non-lawyer. So from a public policy perspective, think of the $250 issue, right? If you needed to provide a refund to this client, how would you do so, right? And all you were paid was $250. How do you know that that was what the client paid, right? The client probably paid more. How do you refund the rest of that money? But how does this work with foreign clients, right? Luckily, there's some guidance documents from the 80s about dealing with foreign intermediaries and like trademark agents and foreign counsel. Those OG notices from 1985 and 1986 basically say that in some circumstances, something like this would be appropriate with foreign clients, but as it relates to domestic affiliations, it probably is not okay. And then a couple last minute tips that we can probably go over would be the life outside the practice of law. So something like fleeing the scene of an accident, like a DUI, could land you in hot water with OED, right? So this was Christopher Mitchell, I believe. This was in Virginia. He was alleged to have been engaged in driving under the influence and leaving the scene after an accident. He was interim suspended for his conduct, which again had nothing to do with the practice of law or practice for the USPTO. But just like in your state, your life outside the practice of law, whether it's criminal, civil, whatever, is subject to discipline. And then, of course, so is reciprocal discipline from other bars. In fact, it's actually mandatory for the USPTO director or the OED director to file charges against you for this. So within 30 days of being, disciplined, you're actually supposed to report this to the OED director, and then the OED director shall file charges against you. And then as a side note, the Commissioner for Patents, Commissioner for Trademark, each can also exclude both applicants and practitioners. It's usually against foreign trademark practitioners. Yeah, it looks like we have run out of time. So I'll put my contact information here. I'm always happy to chat. Feel free to check out our website. We do have a blog. It's ipethicslaw.com. And we're always happy to chat. So if you have any questions, I'll stay around for a bit. But otherwise, it was great to present to you all.